Hey folks, we're back. And now we're going to look at tenancy and leaseholds involving real property. So a lease is a contract granting the use of certain real property by its owner to another for a specific period in return for the payment of rent. The person granting the use of the land is called the lessor, while the tenant is called the lessee. In their strictest meanings, these are terms that are only associated with leases, while the term landlord and tenant are more broad and refers to parties under a tenancy at will as well as parties under a lease. The interest that is conveyed by a lease is called a leasehold estate and was treated as personal property at common law. The following are leasehold estates: tenancy for years, periodic tenancy, tenancy at will, and tenancy at sufferance. So a tenancy for years is an estate for a definite or fixed period, no matter how short or how long. But by statute in some states, if a tenancy for more than 100 years existed, it created a fee simple estate, which prompted the use of 99-year leases, which would prevent turning into something you didn't want it to be. Some states required that a tenancy for years be in writing to be enforceable. Others require the writing only if it exceeds a year. Even further, some go so far to say it must be recorded at the clerk's office, clerk of the circuit court, or the county courthouse, or whatever it might be. Know what the laws are in your state. A periodic tenancy, also called a tenancy from year to year, is a tenancy that continues for successive periods until one of the parties terminates it by giving notice to the other party. It is created when a lease agreement has no specified ending date. This tenancy may be created by implication if the landlord accepts rent payment from a tenant whose lease has run out, who's wrongfully in possession of the premises. Some states do not recognize periodic tenancy. Tenancy at will is an estate in real property for an indefinite period. No writing is required to create this tenancy, and it may be terminated at the will of either party by issuance of the proper statutory notice. And a tenant who wrongfully remains in possession of the premises after tenancy is expired is called a holdover tenant or a tenant at sufferance. Such a tenant has no estate or title, but holds possession wrongfully. They are there and they shouldn't be. Whereas under a lease, you have rightful possession of the property for the duration of your lease. And as a tenant at sufferance, you're not entitled to notice to vacate. You are liable to pay rent for the time you are there. A lease conveys an interest in land and transfers possession. A license to real estate conveys no property right or interests, but merely allows a licensee to do certain acts that would otherwise be trespass, an unauthorized intentional entry on land that doesn't belong to you. So a person who occupies a room, okay, has a license to use that room. A person who pays a landlord consideration to put a sign on the side of the building has a license to put the sign there. But they do not have possessory rights for the actual property at all. Tenants have the right to enjoy quiet enjoyment of the leased premises, which means they have a right to possess the property and be undisturbed in the possession. If the landlord walks the tenant out or interferes with the tenant's possession in any way, it is a breach of the tenant's right to quiet enjoyment. When real property is rented for residential purposes, an implied warranty exists by the landlord that the premises are fit for human habitation. This is known as implied warranty of habitability. In general, to be habitable, the property must meet the sanitary code of the local community, or the landlord, depending on statute specific to the state, may lose the ability to payment, collect rent, while the situation is being corrected. In some states, it pays the court. Okay, the tenant pays the court, and while they pay the court, they cannot be evicted because they are fulfilling their end of the bargain, so to speak. In other states, tenants may pay for the correction of the situation, and that is deducted from the cost of their rent. An eviction is the act of depriving a person of the possession of real property, either by re-entry which means the landowner, the landlord, re-enters the property, okay? Goes and takes back his possessory interest that was given to the lessor under the lease, or by legal process. A landlord forced to evict the tenant. Instead, the landlord must give the tenant notice required by state law and use legal process to evict a tenant. Retaliatory eviction is the eviction of a tenant for reporting to authorities sanitary code or building code violations in the rented property. This type of eviction is illegal in most states. It also demonstrates evidence of being a crappy human being. A constructive eviction occurs when the landlord does an act that deprives the tenant of the beneficial enjoyment of the premises. So, refusing to pay the oil company to deliver oil in the middle of winter in New Hampshire would be probably something along the lines of a constructive eviction. Can't live there, so you have to leave to go somewhere else. And when a constructive or some other illegal eviction occurs, the tenant has the right to leave the premises without being in breach of the lease. The tenant may also withhold rent for the length of the eviction. So if you are even less of a human being under a constructive eviction, if you walk out, the landlord can't say you owe me 9 months rent because you're breaching the lease. Tenant doesn't even take time that they're not there. So fairly strong laws here. The legal action used by landlords to evict tenants was called ejectment at common law. Today, it varies from state to state. The landlord is required to give the proper statutory notice to the tenant before commencing such actions, and the court, in its discretion, may allow time for the tenant to find another place to live. So what if someone gets injured on this property when something is leased? What about that? Well, when a person is injured on rented or leased property, the one who is in control of that part of the premises where the injury occurred is generally responsible if the injury was caused by negligence. What that means, the landlord may be responsible in common areas where they have control, hallways, stairways, lobbies, something that everyone in the building can use. The tenant may be responsible in their own apartment. Legislation in some states has changed this common law tort. It allows the tenant to give notice of an unsafe condition in a part of the premises under the tenant's control, and thereby makes the landlord responsible for the injury caused by the unsafe condition if the landlord fails to correct it. And we'll see that this plays into injury on premises in the mortuary law book when we talk about funeral home establishments. Folks, thank you for your attention. We will see you next time.